Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'm actually not in a coffee shop today. I am on a train going to my Upland office in San Bernardino. So if you hear the conductor in the background and so forth, you know why. Okay, the provisional waiver regulations have become final, okay? Meaning that finally we are able to have the regulations as part of the law to be able to submit a stateside waiver, which is referred to as either an unlawful presence waiver or a stateside waiver, however you want to refer to it. But for pretty much a year now, it's been going on with the preliminary regulations and then the final regulations commenting period and so forth. And we've been waiting for some time for the regulations to become final and issued so that we could actually go forward and know what to do and what the issues are regarding the final regulations. And so I have another video specifically designated to help with the preparation and what needs to go into the unlawful presence waiver or a typical waiver, how you show the hardship and what documents and so forth you need to submit. But in this particular video, I want to go more over the new procedures and the ways that you file the waiver, the issues that come up, and how it will affect your ability to not be separated from your loved one for long periods of time, and other issues which have been declared and submitted in final form by the regulations. So we'll go over those and we'll see what issues might pop up in the future, but at least for now we will be able to determine what and when needs to be done. Now keep in mind that even though the regulations are final, you can't actually submit the provisional waiver until the March 13th of 2013. So it does take time to prepare a good waiver, and I want to stress that just because it can be filed here inside the United States does not mean that it can be done easier or that you don't have to submit the appropriate evidence. Clearly, it can still be denied, and the discretion is with USCIS. So you want to make sure at the outset that it's done professionally, the best it can be done, and don't think that you can give it your best shot, do it yourself, and if it doesn't work, then you'll get a lawyer. Especially because there are no appeals, there are no motions to reopen, there's none of that. So let's get to it. So first let's distinguish between what is a provisional waiver and what's a normal waiver. Well, the provisional waiver deals just and only with if you have been unlawfully present in the United States and you're subject to the bar of 3 to 10 years because you've been unlawfully present. If you have any other issues of inadmissibility, such as fraud, crime, medical, prior deportations, anything like that, then the provisional waiver doesn't apply to you. Now, it doesn't mean that you can't clear things up in order to try to then make it apply to you. So for example, if you have a crime that you would need to do a criminal waiver, you could theoretically do a motion to vacate that crime in court, and if it's successful, then essentially that crime never existed, and then you no longer need a criminal waiver, so then you are eligible. Or by the same token, if you have a prior deportation order, theoretically you can do a permission to reapply, get that approved, then you're no longer subject to being inadmissible because of a prior deportation order. So all of that goes to different ways that you can become eligible for the provisional waiver, even though at the present time you might not be. So who provides the decision on the provisional waiver? Well, that's going to be USCIS and only USCIS. It's not the immigration judge, it's not Department of State, it's not the U.S. consulate or U.S. embassies, or it's not overseas offices of USCIS. It is only inside the United States, USCIS. They're the ones that will provide it. And they will send the decision to either the well, actually, they'll send it to you, the applicant, and they'll also send it to your attorney. So, there's ways, even if, I'm just going to tell you, even if it is denied, there are ways to either file again or to rectify the situation. But then why would you take that chance if you can get it approved in the first place? So the written decision will be sent by USCIS. So we've gone over a little bit, but where exactly do you file the provisional waiver? Well, all applications for the provisional waiver, or the unlawful presence waiver, will have to be filed by USCIS. They are the ones that will make the decision as to whether or not you qualify. Okay? Now, if you happen to be in court, USCIS doesn't have the jurisdiction to rule on a waiver at that time, but then neither does the judge. So what can you do? Well, if you're in removal proceedings, you need to have your attorney make a motion to administratively close the removal proceedings, and then once it's administratively closed, make sure that it is not recalendared. And if it is administratively closed and not recalendared, then you will be able to file the provisional waiver with USCIS, even though you were in removal proceedings. So that's the way you would take care of it from there. So there's some other issues. A lot of people will think because they can file it while they're in the U.S., if they file it, can they get a work permit? Can they get advanced parole to leave the United States temporarily? The answer is no to both of those. There's no authorization for a work permit that comes with this, no advanced parole. So even though you can stay in the United States essentially while it's being adjudicated, it doesn't really at that point change your status or give you the ability to get a work permit. So the question then becomes, who is eligible to apply for the provisional waiver? I mean, there's lots of people out there who are unlawful, lots of people who obviously don't want to leave and wait years outside for a waiver to be adjudicated. So who qualifies? Well, here's the issue. If you're a foreign national, obviously, and you are inadmissible only on unlawful presence grounds, nothing else, and then if you're inside the United States at the time you file the application for the unlawful presence waiver, and upon leaving the U.S., you would be inadmissible only because of unlawful presence. This is the key. If you go to an attorney to do this and you forget to tell the attorney about a crime you had 12 years ago, or something else that makes you inadmissible, then that's going to kick you out of eligibility. So even if you think you're eligible and get an approval, if you leave the United States and you're really inadmissible on another ground as well, then this waiver won't work for you. And okay, you must be an immediate relative. So this means that you're the spouse of a U.S. citizen, unmarried child of a U.S. citizen, or the parent of a U.S. son or daughter who's 21 years old. You would be able to qualify, and you have to be the beneficiary of an approved immediate relative petition. So that's basically an I-130. So if you get the I-130 and it's been approved, and the case has to be sent then to the Department of State, which is the NVC, for the beginning of visa processing, and you have to pay the visa processing fee. Okay, so again, just to clarify here, if you were to get an I-130 approved and file the provisional waiver at the same time the I-130 is approved, it won't work. timing is not correct. You have to wait until the case is sent over to NVC, a case is started, you pay the immigrant visa fee, and then you are able to file the provisional waiver. You also have to notify the NVC that you are going to be filing the provisional waiver, because what they will do is the NVC, or technically Department of State, will then put a hold on sending the case to the U.S. Embassy or U.S. Consulate where you are, and they will wait until a decision from USCIS on the provisional waiver is made. So assuming you file at the right time and it's approved, then once it's approved, USCIS will notify Department of State, and then they will proceed to send your case file overseas or wherever the U.S. Consulate or U.S. Embassy happens to be. So that would be it. And another element or requirement, obviously, is that you're going to depart from the United States at the appropriate time to obtain the immediate relative immigrant visa. And of course, the waiver itself, that you meet the requirements for the waiver in that you can show extreme hardship to your U.S. citizen spouse or parent. Okay, so the bottom line is if you don't have a spouse or a parent that's a U.S. citizen, and normally for the waiver, normal waivers, you can also show if it's a lawful permanent resident spouse or parent, to show the hardship, but the regulations specifically here say U.S. citizens, so that's an issue to look at in the future, whether they inadvertently left off that it would be a lawful permanent resident or not. So in that particular regard, we'd have to check in on that, but you obviously have to have a qualifying relative in which to do the unlawful presence waiver. If you don't have the qualifying relative, you can't do it. Now, so those, and I know I put a lot of commentary in between the various elements, but those would be the requirements if you qualify to become to file the provisional waiver. Now, the opposite side of the coin is which persons do not qualify to file a provisional waiver, and in that respect, we've gone over it a little bit. Some of the items that will occur if if you determine that you don't, like for example, we said if you leave and you're inadmissible on another section of law, then you're not going to qualify. And remember, this is just the unlawful presence waiver. So here's the ones. Obviously, if you are subject to any other ground other than unlawful presence, you don't qualify for this waiver. So again, with that, don't just think, well, that's it. You have to for sure go overseas and do the waiver after the interview at the U.S. Consulate or the U.S. Embassy, because again, we might be able to look at what other grounds you are inadmissible and take care of them prior to you having to file the unlawful presence waiver. Another ground is that the alien or the foreign national is under 17. Well, the reason for that is there's an exception to the unlawful presence, in that, and actually if you're under 18 and 5 months actually, then you're not subject to unlawful presence, so there'd be no need to file a waiver in that regard. If you do not have a case pending with Department of State, which we spoke about, again, you have to have the approved immediate relative petition. You had to have paid the immigrant processing fee and it had to be transferred to NVC. If all of that hasn't occurred, meaning, if you don't file it at the right time, then you are not going to be able to qualify for this waiver. There's also a date here. A lot of people are thinking, well, great, now since the waiver is final, I'll be able to just pull back what I already have and get it filed over there. Well, that's not the case. If you had an immigrant visa interview scheduled prior to January 3rd, 2013, then you're not going to qualify. Okay, you cannot have had uh, an interview scheduled at that time or before and think you now can file a stateside waiver. And this also means if you had previously tried to continue that or to reschedule it, it doesn't matter. If the first interview was set at that time, then you won't qualify for the provisional waiver. Now, that doesn't mean that there might not be ways around that. So for example, if the petition's withdrawn, if it terminates and then you file another I-130 from scratch, I mean, there's different ways that I can foresee going about this so that, even if you had the interview but didn't go, we might still be able to rectify the situation to be able to allow you to file the provisional waiver, keeping in mind there's a lot of new issues that pop up here, and obviously we would try to make it so that, whatever the circumstance, that you wouldn't have to leave the country while the waiver is being adjudicated. Okay, now, also the people won't qualify if they're in removal proceedings unless, as I stated before, they've been administratively closed and not recalendared at the time of filing the form, and also there's a new form. The normal form for waivers, Form I-601. The one for unlawful presence is Form I-601A. So I want to also make clear that the form itself is not the entirety of the waiver. In fact, I liken it to, it's a little like the book cover. Okay, some people think they just fill out the form and they're magically going to get the waiver, and it doesn't work like that. What I do, what my firm does is, of course the form is filled out, but then we have the attorney cover letter, the declarations, affidavits. We have all the supporting evidence to show the hardship, because that's the bottom line. I mean, we have to show the hardship to the U.S. citizen, spouse, or parent. So there's also, which I discussed in other videos, essentially other ways of doing that, and additional ways. We get a psychological report of hardship, a professional expert letter on the hardship that would be suffered. Okay, so those are the basic ramifications of who qualifies, who doesn't qualify, and so forth. Now, what exactly do you need when you file the provisional waiver? Well, of course, you need the application for the provisional unlawful presence waiver, and you need to pay the correct fee. And it needs to be sent to the proper place at USCIS. Just little things like, it has to be properly signed. You have to provide the family name, domestic home address, and date of birth. If you think you can file it and put a P.O. box or, some other address other than where you live, that's not going to work. So you also have to provide evidence of the approved petition. You have to provide evidence that the immediate relative is a U.S. citizen. And you have to meet all the various requirements, and you have to show that there has been no interview scheduled as of January 3rd, 2013. Now, there is also a requirement that you need to take biometrics, okay, which means you're going to have to go and take your fingerprints, and they're going to run a criminal background check on you. So obviously don't think that if you have a crime 20 years old that it's going to disappear and that they won't find it. Obviously, if you have a crime or you're inadmissible on another ground, you need to tell the attorney so that, for example, I would be able to pull the criminal records. I'd see, what exactly happened and see what possibilities are to try to vacate those so you would be eligible for the provisional waiver. Now, if you do submit this and you don't go to the biometrics appointment, it's gone, okay? The provisional waiver will be denied. And there is no appeal or motion to reopen for abandonment on this. So if you don't do what you're supposed to do when you are supposed to do it, then it for sure will be denied. Now, the burden of proof is the same. Again, I have a lot of people who think just because the provisional waiver is, going to be able to be filed inside the United States, that it makes everything magically easier to get approved, and it's not. The burden of proof is exactly the same. and you need to convince the officer that it should be granted. That's the bottom line. That's what I do. Really, it's like a scale. You have the good stuff on this side, the bad stuff on this side, and you do everything you can to make the officer cry by the time he or she is done reading the the whole petition. So that's pretty much how that will works. Now, if it turns out that it is denied, then there's no prohibition on filing a regular waiver at the time that you would leave, and you would then file the regular waiver while you're overseas. I know that's not a real appealing thing here, because if you get it denied from USCIS, what's going to make you think you'll get it approved later? But for those people who, for example, do it on their own and they don't do it properly, the door's still open to file a regular waiver. But again, why would you do that if you have to wait outside for a year or 2 years when you can do it all in here? This whole process is meant to streamline the waiver procedures so that the beneficiary or the foreign national doesn't have to be separated and show, from the family members this whole time. So that will pretty much cause it. Now, once the decision is made, there can be no withdrawal of the waiver request. So let's say, for example, you do a waiver on your own and you realize, oh, geez, you didn't submit this, you didn't submit that, you don't think it's that strong, you made a mistake. As long as the decision has not been made on the waiver, you can withdraw it. And if it's withdrawn, then it can be refiled properly, okay, with all the supporting documents. And as stated before, there's no motions to reopen or reconsider a denial of a provisional waiver, unlike most other parts of immigration law. So it's like you get one shot at the apple, and if you don't do it right, it's gone. And again, we could try to find some ways around that, but if you have the opportunity, for example, to call me and we'll discuss what's necessary, and it's like insurance. You get car insurance. You don't expect to get in a car accident, but if you do, you have the insurance. So same thing with the waiver. The waiver is what's preventing you from getting the green card. That's the bottom line. That's the door that needs to be opened. The waiver is both harder and more important than the underlying petition itself, because without an approved waiver, the door is closed. So you want to make sure that of anything you do, that the waiver is as strong as it can possibly be. Okay, and so the validity of the waiver, how long does that last for? Well, basically the waiver, even if it's approved, it doesn't actually take effect until you leave the U.S., okay? And then once you leave the U.S., you'll have an interview, and if everything goes smoothly, then you'll have the interview, and you won't be inadmissible because you'll have an approved provisional waiver, and then you'll just come back as a lawful permanent resident. Now, if at the time of the interview, this is key here, if at the time of the interview it is determined that you, in fact, are inadmissible on another ground other than the unlawful presence, then the provisional waiver grant is automatically revoked, okay? So very important to make sure you disclose everything to the attorney when doing the provisional waiver, so that you don't get an approved one, leave thinking everything's going to be perfect, and only to find out that you're inadmissible on some crime you committed 20 years ago, okay? So there's a lot of issues with this. And also one other thing, if you leave the United States with the approved provisional waiver, but then for whatever reason don't want to wait the 2 weeks or 3 weeks or whatever it's going to take, and you just come back illegally, the provisional waiver is automatically revoked. So obviously don't do that. So I'm glad and pleased that the new regulations are final, that we can finally move forward, and that we have the means in which to do it. So please give me a call or go online, set up an appointment. It's blerner.checkappointments.com, or email me at blerner@californiaimmigration.us. Either way, I'll be happy to give you a free consultation, let you know what can be done, and then we'll go from there. More in the coming videos.